All right, well, it's the top of the hour, so it's high time that I got started. Welcome, everyone. Once again, I'm Matthew Savari, and welcome to the final in our series of the Business of Bioscience Bootcamp. Just to recap, we've had 4 sessions so far, and this is our 5th and final, the basics of licensing a university to an IP startup. I'd say that this is in some ways the culmination of our series, because we talked a lot about the tactics and individual steps that it would take for preparing your technology for its eventual commercialization. But what we're thinking about here is the final tactics of getting the technology off the campus. So once again, this is the basics of licensing university IP to a startup. We're joined here today with Rick Friedman, founder and CEO of Novus GC. Per usual, the Q&A function will be available throughout the entire presentation, and the slides and the video of the presentation will be emailed to you and all participants who've signed up for this lecture series in the week to follow. So without further ado, I'm going to stop sharing and hand it over to Rick Friedman to introduce himself.
Great, thank you, Matthew, and let me start sharing here. And I trust you can see the PowerPoint now and not my notes.
We can.
Okay, great. Give me 1 second to get things adjusted here. There's always things to move around. Great. Well, welcome everyone to today's presentation. And my name is Rick Friedman. I'm with Novus GC. We serve as general counsel for early stage technology and life science companies, guiding them through angel and venture financing, licensing, and other transactions, as well as helping them get started, get the formation part. I put my brief bio up here on the slide. The 30,000-foot view of my experience includes a decade in Silicon Valley, working at big law firms, working in-house, and working in tech transfer. And I've been around tech transfer for 16 years now. I spent 9 years inside universities in business roles in tech transfer. And for the last 7 years, I've served as counsel for companies, mostly startups who were licensing from universities. And the topic of today's presentation is basics of licensing university IP to a startup. And we're going to look at it initially through the lens of a license term sheet. And then we'll take a step back and talk more generally about IP rights and university IP and licensing generally. And I want to strongly encourage you to ask questions as we're going through. There's a Q&A function, and if you type your question in, then Matthew will alert me that it's there, and we can cover it. And I feel like these presentations go a lot. They're more fun and flow better when people ask questions as they have them, just because if you have something in your mind, probably other people have similar questions. So it's great to field them during the presentation. Okay, so we're going to start by looking at a license term sheet, as I said. And first question is, what's a license term sheet? And the term sheet is actually not the license itself. We're going to pull a sample up in a second, and I'll show you where you can download that as well. It's often the one we'll be looking at is 2 or 3 pages long, and the term sheet will often be that length. So it's not actually granting rights in anything. It's the rights will be granted under a separate license agreement. What the term sheet is it's a tool to facilitate the negotiation of the principal terms of the license agreement before the agreement is prepared. The idea is that before you go through the more in-depth process of working through a license agreement, you figure out if there's actually a business deal first, and you figure that out by a process usually of exchanging drafts of the term sheet till you come to rest on business terms that are both acceptable to both the university and the startup. And they're typically non-binding. The exception I'd say that gets somewhat binding is that if you're taking an option from the university, so a lot of times when startups are starting up, they will, instead of going directly to the license agreement, they'll get an option for a period of, say, 6 or 12 months. Sometimes these aren't options, but letters of intent from the university. It depends on the university's specific practices, but it says, hey, either you have an option to exclusively license this, or it's our intent to exclusively license it. And in some cases also, when you're doing that, you will negotiate a term sheet at the front end while you're doing the option and attach it, as this will govern the terms of the license agreement should we choose to exercise the option. And the final thing I want to say about term sheets, it's a great way to orient ourselves around what we can expect to see in the license agreement, because this license agreement is going to be this, usually they're 25 to 30 pages, but at some research institutions, they're 50 or 60 pages. And so there's a lot of legalese and operational stuff that's going on in the license agreement. This gives us a snapshot at a very high view of what the business terms are of the license. So in a moment, I am going to exit the presentation and pull up a Word document and go through it. If you'd like to also download this Word document we're going to be doing, you can access it here. If you go to novusgc.com/webinar-series, you'll see what we have here under part 3. It says download term sheet, and you can do that. And I think Matthew is going to put into the chat these links so that if any of you want to download that, you can do that. And this page that you'd be going to here, I just want to mention that is, we just last week completed a 5-part webinar series, which was, I think it was University Licensing 101. It was a 5-part series, an 1.5 hour episodes. And so it's 7.5 hours of total content on this subject. It's actually linked here if you want to go back and get some more in-depth on some of these topics. And I also bring that up is just to show we spent 7.5 hours on a webinar series going through these topics. So there's a lot of depth you can get into these subjects. We're going to be kind of scratching the surface today and hitting some high-level concepts, but that's also why I encourage you that because we're not going to be going really in depth on any of these topics in particular, that if you have specific questions, please ask them. So I'm going to stop sharing for a moment so I can just pull up the Word document and we can start going through that. Sorry, give me 1 second and I'll be sharing the right screen. There we go. I trust now that you can see a Word document up on my screen, which is, it says patent license agreement, non-binding term sheet. And so I'm just going to just show you the length of this document before we start going through the individual fields. The document that's the first page, second page. It's a 2-page document. So in these 2 pages, we're going to go through the different fields that you'll customarily see in a term sheet. And this term sheet was intended just for an exercise like this to talk about the high-level concepts. It's not exhaustive in terms of the type of things you may want to put in term sheet, but it does exemplify most of the important concepts, and it gives us a jumping off point to talk about them. And so I will start in, and Matthew, if there is questions or anything, if you unmute, I'll see that and can jump in. So starting at the top, there will be the licensor will be a university. In many cases, you might be working with a technology that actually is the product of a couple different universities. And in that case, the licensor may just be the lead university or both universities. But in that case, the lead university will have an agreement with the other university that will give them the rights to negotiate this agreement. But it's not uncommon at all in tech transfer to have jointly owned patents that come out of the research because of the nature of the grant work that's done and multi-institution collaboration. The licensee is going to be an entity that's formed. In most cases, this is going to be a Delaware C corporation. That's like a whole nother topic of the type of entity. But by the time you get to doing this, you'll have your entity formed that will be the licensee. Now, the next item here on the term sheet is going to be the identification of what is actually getting licensed. And this is a common way to do it, where we reference the patents that are on Exhibit A. And in this case, Exhibit A isn't populated because this is just a template, but in there you would list the patents. And I want to pause on this for a moment because there's a couple important aspects here. The first is that these licenses are for very specific patents. The university is not going to grant a license for anything beyond specific patents that can be identified that it knows that it is not licensed already and that are available for licensing. The second is that the very nature of not all university licensing. There's plenty of university licensing that is just around, say, for example, software, or it could be other materials. For example, biological materials or data. There are other things that of value that can be licensed by the university, but the preponderance of what does get licensed, the licenses are patent rights. And so bring that up because it's important for the startup to really understand what the patent rights are and are not. And when we get through this term sheet, we have a few slides that we do talk about what are patents. But an important aspect of it is understanding you're getting these patent rights, and patent rights can vary really very widely in terms of whether they're useful or not, whether they really protect you from competition or not, whether this application you applied for is likely or not to result in any claims that are of any commercial value. And one of the things that frequently we counsel our startup clients on is to find their own patent counsel for the startup that has expertise in the technical area of the technology to be advising the company on that aspect. So we'll come back to that more later, but I just want to highlight that the very essence of what is happening in most of these licenses is a patent right. So it's incumbent to understand what the patent right is and isn't, and how strong the patent rights are or can be expected to be. The next thing in the term sheet here, we talk about technology rights, and this can vary a lot in terms of whether licenses are going to include these or not. So you might have at the base of your license patent rights, but then the question comes up, is there anything else of value in the university that needs to be transferred? Because the patent rights actually isn't really so much a transfer, it's a grant of rights in these intangible intellectual property rights or legal rights. Whereas if there's data you need, if there's materials you need that are in the lab at the university, then those will be technology rights, which will be appended, and included in the license. And or there might be software. And there's plenty of times though where the software itself is the basis of the university license. So I'm just going to pause for a second and take my breath, see if there's any questions, and I trust, Matthew, you'll interrupt if there are.
Looks like we don't have any questions quite yet, but
Okay.
Let's pause for a couple of moments.
Okay. All right. So going on then, so what we talked about already was the patent rights and the technology rights are the stuff that's getting licensed. The next is like, what are the next important thing is the license grant itself. These are the rights that are being conveyed. And typically for a startup, it is going to be an exclusive license that we want to be the only one with these rights. These are going to be the barriers to competition. They're going to enable us to raise money, to develop our products, and to compete successfully in the market. So the expectation is it will be exclusive. Universities are invariably going to reserve rights for their own educational, research, and clinical purposes and extend those rights to other nonprofit research institutions. That's pretty non-negotiable from most universities. And we'll talk about this a little later. If there was government funding used in the development, the US government's going to maintain some rights for government purposes. And it's possible in some cases that there might actually be some pre-existing licenses out there. That does happen. One example could be that, yes, something was either licensed previously and came back to the university, or maybe it came out of some industry-sponsored research, the work at the university, so that industry sponsor has some rights. And generally, while the patent rights, the university grant can be exclusive, that is generally not the case if there's the technology rights, the type of things we talked about. And in that case, often these will be non-exclusive. So the next area that gets discussed in the term sheet are going down here, and to describe overall what the rights are is the field of use. And there's two very different, there's different schools of thought on this. From the university standpoint, the universities typically will tell you that they want the technology to be used as broadly for as much social, good as possible. And if a technology has two different applications and the startup is focused, for example, on medical applications, but there's also, say, industrial applications available that the startup just isn't going to have time for, the university is going to say, hey, you go work on the medical, that we'll give you a field of use for, use in for human, diagnostics and therapeutics, but we've got these other industrial applications and we want the ability to go license it to someone else who can exploit that. So that's a common conversation. Now, often the technologies themselves really don't have that type of dual purpose. And from the startup standpoint, sometimes things are going to change, that they're going to pivot, that they're developing technology for one field of use. And it turns out that, the market didn't really prove out there, but in doing the work, they realized that there's other market for it, which actually wasn't described in the field of use. And from their investor standpoint, they want that optionality to be able to pivot. And there's lots of compromises here where there are multiple fields, where sometimes you do start with the more limited fields, or sometimes you ask for all fields of use. But then if you're not exploiting a field and someone else comes along to do it, the university can say, hey, either you have to sublicense to them or you have to exploit it yourself. So that is a topic of conversation during the license negotiations frequently. Next up is territory, which is almost always worldwide. So now we're going to get into the economics. The kind of the bulk of what we have here are going to be economic terms. And the thing that's interesting about licensing intellectual property is that now it's possible to value it. And it's possible you could get a valuation firm that could come back and say, we've done our valuation, we've looked at all the potential for this, and we think the technology is worth $5 million or $1 million, whatever it is. That's typically, that is a way to value technology, and sometimes transactions do happen that way, intellectual property, but that's not, that's much more rare for that to occur in the university context, especially with startups who, often have very little resources at the beginning. And so typically there is an economic arrangement structured where it's more risk sharing, where even though the technology could theoretically have a value of $1 million or $5 million, the startup doesn't have to pay that upfront. The startup may have, there will be some things the startup's required to pay upfront. We'll talk about it. The startup's likely to grant equity to the university, but a lot of the economics for the university are deferred until, if and until the company is successful. And there's a combination of different economics that we'll look at now, but it is this, these are kind of an overall combination of economics, and they will trade against each other. So for example, if you're making an argument to lower, for example, the royalty, the universities may say, okay, we can do that, but we're going to need more equity in terms of what they feel is the appropriate mix based on the technology and comps. And the one other thing generally about the economics of these licenses for startups is they tend to be very back-end, or more back-end loaded. If the university is dealing with an established company, maybe it's big pharma or Fortune 500 company that has plenty of cash, they may be interested in paying more cash upfront. They can afford to pay more cash upfront, and to potentially reduce royalties down the road. But for startups, typically it's going to be more back-end weighted and more risk sharing between the startup and the university. So the combination of economics we're looking at, I think I'm going to skip upfront fee for a moment. These two right here, the equity and the running royalty, these really are the focus of, I'd say there's other important economic terms, but these are kind of the headline rates that people tend to think about. And I'm going to skip down to running royalty first. So this is the royalty based on product sales. And it's a number that's negotiated. It is typically almost invariably low single digits. And there's, depending on the industry and comps and norms, and I could provide some relative ranges where these fall in, but they're low single digits. Now, there's also often, if technology rights are licensed as well, there will be two tiers. There will be the tier for when the patents cover the licensed products, and there'll be another tier when the patents don't cover the licensed products, but that the licensed products incorporate the technology rights, or maybe were developed using the technology rights, depending on how the university license is written. So it'll be these tiers. And the reason it's structured this way is because, as a matter of law, you can't charge a royalty on for when you give someone a patent license. You can't have the royalty continue to accrue after the patent expires. There was an old Supreme Court case that was affirmed just 4 or 5 years ago that says royalties are unenforceable after the patent expires. So what will happen is there'll be a step down after the patent expires to reflect the fact that there are no longer patent rights being practiced in the products. So this is the royalty, and before we leave royalty, there's a few important things that will often get negotiated besides just the royalty rates themselves. And those are, there's some things that they're not noted in this term sheet, but they often will be noted in the term sheet, where if you're selling a product which is actually a combination of being sold, think of as a kit, maybe you have your product and it's sold as a kit with a second product that doesn't use the licensed patents. When you have that combination product sale, how you allocate revenue. So that's a common provision that's negotiated in the term sheet. And another one is what people will call stacking or anti-stacking, which is if you actually have to go out and get a patent license from a third party to make the products, that under one of these anti-stacking provisions, you can reduce the royalty payable to the university in that context. So those are kind of the highlights on the royalty. And then the practice has really, the expectation, I would say, around universities licensing to startups now is that there will be equity, that there will be a stock grant made from the startup to the university. Those equity rates are often, the amount of equity I'd say is probably a little, if you want to think of the royalty rate as X%, the equity may be a bit more than that. And it's been changing a lot over, I've sort of seen norms seem to be changing over the last few years, but it will be common stock. It gets issued to the university for the grant of the license, and it doesn't vest. So in many ways, it's like paying an upfront fee, because you grant it to the university, and we'll talk about this a little later, but you can terminate, if you're the startup licensee, you can terminate the license anytime if you decide you don't need to use the patents or technology anymore. But if you do, the university keeps everything you've given them, including the equity. So there is this equity grant, it's common stock. There's some variation on how some universities handle it. Some want some rights that get associated with that. In some cases, there's some universities that actually don't want to hold stock themselves, and they hold what we call like a phantom interest in it, that it's a payout upon sale or IPO that mirrors as if, amount of money as if they would have owned the shares. But the one other thing that's important to talk about here is that there is anti-dilution almost invariably built into university licenses, that they want to make sure that they have a certain percentage after either a certain amount of money is raised or after a certain post-money valuation. Those are the two flavors we tend to see in these. Because if they get 5%, say, from day one, based on what the other founders have, they can get diluted a lot before any meaningful money comes in. So the university standpoint is we want to make sure we have equity measured at a time when there's been some meaningful outside investment that's come into the company. And then often many universities will negotiate participation rights so that they have the right to purchase stock in future rounds, to at least maintain their pro rata interest and possibly more. And I think when I started in tech transfer 16 years ago, I think Stanford was about the only university that was doing that. But today, many more universities have their own funds that they can invest in it. And I mentioned that webinar series that we completed last week. Our sponsor of that was Osage University Partners. They've partnered with a lot of the major universities, and they have an arrangement where they will exercise the participation rights that the university have and provide some of the benefit back to the universities. So I'm going to catch my breath for a moment there, and I see there's one question. And Matthew, I don't know if there's a question that's appropriate at this time.
So the question is, do you ever see some kind of vesting for university equity? For example, vest as long as the license is maintained by the licensee?
Yeah, I have never seen it. I've never seen it. I've seen people ask. I've not seen it been granted. I've seen a lot of licenses, and I haven't seen that. It's conceivable that could be negotiated. Part of the equation on this, though, is this part that when you're negotiating the license, and that's actually a great segue to this box that I skipped over initially, which is the upfront fee. When universities are talking to established companies, they may be looking at upfront fees of $500,000 or greater, depending on the technology. And that amount of money will rarely fly with a startup. And some of the universities like seeing 50,000, but often there's just not money in the system to give 50,000 to the university. So the university, from the way they're looking at it, is this equity is a payment to them in lieu of the upfront fee, because the upfront fee is not reimbursable, not recoverable. And sometimes you can schedule it out. So if there is, if the university says we really have to get $200,000 for this, and the startup thinks, well, we are raising money, we can pay this, it might though get scheduled out over a few months or a couple of years to sort of that upfront fee isn't totally upfront. But for that reason, there's not much flexibility. But what I would say about that if the takeaway on that, I would say, is that you don't have to do the license immediately. And that's also another reason we talked earlier about term sheets, about options, is that if you're not sure yet whether you need the university IP, you're not sure whether the business is going, you're not sure what direction the business is going in, it can be a good idea that instead of doing the license up front, because once you execute the license, the expectation is that the equity gets issued then, is that you negotiate an option up front and you have a period of time, say 12 months, to do your evaluation to decide whether you're really serious and you really want it. Because when you are entering into this, there's a lot of obligations you can get out by just terminating, because these licenses generally are going to be terminable, but the equity is just not one of those things. And so that, on this topic of the upfront fee, these generally for startups, especially if they're, faculty led or, the PI led or PhD led, if there's not money lined up right away, that these fees will tend to be on the fairly low side. Often, we'll see them $25,000 or less, but it can be more if there's some venture backing that's in the wings. But again, and that's what the university says, okay, we're giving it to you for a song up front, but that's part of the risk we're taking. So we want to be seen as a partner and have equity. There's no more questions on.
There's another, and let's see if this fits into the normal course of your conversation.
Okay. So
what would be the setup for when the startup or company has a patent and wants to partner with the academia to develop the technology?
Got it. So if I understand the question, and yeah, we'll use it as we can address that now, and then we'll come back into the flow here. And what I understand the question to be is that the patent is actually owned by the startup, and there's no particular technology the university has that's needed by it. And this presentation is very much focused on university-owned IP, and we'll talk about this a little more when we get to the slides afterwards. But the universities are doing tens of billions of dollars of research each year. majority of which is funded by the federal government. I'm pretty sure like this is a UCLA, mostly UCLA audience, I think. So I think UCLA does over $1 billion a year in sponsored research. And so the university on its own is creating all these patents and technology. And the focus of offices like TDG is to be the shepherd and the steward for that technology and getting patent rights and licensing it out. The question that flipping it around to say, well, if I'm a startup and I've got valuable technology and I'm looking for a partner to develop it, there are ways to work with the university. Those ways include sponsoring research at the university. It could be that there's some core facilities at the university that you can get access to and pay fair market value for. And so I actually put it in two buckets. One is there's ways you can actually partner with the university itself, but there's another way you can actually partner with the researchers themselves, because the researcher is entitled to spend a part of their, like basically 20% of their time on outside activities. So you can potentially work directly with the researchers and not bring it in the university. If you bring it in the university and do sponsored research, in most cases, if there's new things developed using the university facilities or developed by the university researchers, the university is going to own that part of it. And then you would be negotiating with them a license like this to get the rights back. So, it's a case of you are going to, by going that route, you may be, helping the university create intellectual property that the university would own, that even though you brought the idea there and everything, the way the university IP rules are structured, they would, in most cases, they would own what comes out of it, and then you'd be having a negotiation to come back. So that's a bit more of a complex topic before getting into something like that. All right, so I will move on now. Again, unless there's any other questions, Matthew, again, feel free if there's any that are pending. So this is, the upfront part of it. We've covered most of the upfront parts, which are if there's an upfront fee and issuing the equity. We talked about the royalties. I want to pause on one other thing here before we leave the royalties. Actually, I'm gonna come back to it. I want to just point out right here that this percent of let's say it's 2% of sales of licensed products. It's not only sales by the company, but if the company has sublicensed the patents or technology to a third party, it's also that 2% of that sublicensee's sales. So an example of that could be that it's a biotech startup. They go do deal with pharma, and the pharma is actually going to take the technology or the drug to market, and then the pharma is going to go sell it. When the pharma goes and sells it and makes $100 for a product sale, in that case, the startup owes $2 to the university, not the pharma. It's the obligation of the licensee. From the university standpoint, they don't care if the sales are made by the startup or its sublicensees. They get paid X% of those product sales. And we're going to come back in a few minutes to sublicense economics, because it gets a little more complicated than that. So the next thing that we see in the term sheet are annual minimums. And this is broken out here. The way I did it for this term sheet, actually, I did this initially for TDG last year. I think I did this for TDG first last year. So that's why it was broken out this way, because this is the way the UCLA license is broken out. Some universities just have one annual minimum payment. But many universities like UCLA break it into two. One is an annual maintenance fee. And the idea of the annual maintenance fee is, hey, we charged you a little bit of money up front, plus you give us some equity. But because you have this valuable right from us, we want you to be paying something annually as well. And it's, again, I mentioned that the economics are an overall mix of economics, and this is part of the equation for the university, is to get these annual fees. And so in the case where it's broken out, there's an annual maintenance fee, and it will be in place until the first commercial sale, because what happens after first commercial sale is you get kicked down into this bucket, annual minimum royalties, where these numbers are actually going to go up. And so these can start, I'd say these annual maintenance fees, often can start as low as $5,000 or $10,000 and work up from there. and often it will be sort of graded up over time. The other thing is this starts on the first anniversary. Sometimes startups will say, hey, not a lot of money in the system now. We're doing early stage work. Can we kick this out and start the second anniversary? So those are some of the things that get negotiated around a startup license. But then there will be an annual fee. And part of it is, like I mentioned, I spent 9 years on the other side working at universities. Is part of the university is just making sure that there's a company there doing something. There's some other requirements that require the startup to be developing the technology, but one thing to really, from the university standpoint, to see if there's a pulse and that the startup's doing something is that startup can at least send a check every year and some minimum amount of money to pay these fees. Then after that, we get to the annual minimum royalties, and here this might tier up a bit also, because when you first introduce product to market, you might expect revenues to ramp. So you might start out with lower minimums and it'll ramp up. And these are creditable generally just towards the royalties due in that year. And so those are the annual fees. Next, I'm going to come back to sub-licensing. And this is the one part of licenses that's, I'd say, the least intuitive. And I think there's part of sub-licensing isn't that intuitive anyway, and takes people, when they're new to this, a little time to get their heads around. We mentioned already that if the sub-licensee sells the product, then there's a royalty that the startup has to pay to the university based on the sales price by the sub-licensee. So there can be another set of revenue streams that come from the sub-licensee to the startup. For example, the sub-licensee may agree to pay $1 million up front for the rights, because you, startup, you have these valuable rights, and you're able to extend these rights to the sub-licensee through the grant of the sub-license. So there's another set of economics that deal with that non-royalty sub-license revenue. And since we're going super high level on this term sheet, and there, like I said, there's lots of little alleyways we can go down. We're not going to talk about what's included and not included, because there's lots of common carve-outs from what gets included here. But the general idea is, when you get that non-royalty income, you're going to share a portion of it with the university. And these rates are going to be higher, often significantly higher. There's been some more recent trends on how some of these are getting negotiated, but these can start at 20 to 25%. That's actually a very typical starting point for universities, is in that range. Some actually start higher. When they get negotiated, depending on the technology where it is, they can get negotiated a lot lower. And they can also get negotiated lower based on how much value that the startup has added. Because from one standpoint, the university says, hey, we're giving you these technology rights, and you can go out right away and flip them and get a bunch of money for flipping the rights we gave you, which generally is not the intention of the startup. So there may be an idea that it's going to start higher, but once milestones are met, then the startup's in the position to say, hey, we've added a bunch of value. We did not go out and flip this technology, and because of the value we added, we just shouldn't have to share such a large percent. And so that's how the negotiation goes in defining that.
We have a really quick question about the lower end of upfront fees that you've seen for startups.
The lower end of upfront fee for startups.
I can phrase it exactly as the question was asked, is what's the smallest upfront fee you've seen for startups? Do some universities have a minimum dollar amount?
The minimum fee is $0. And now that I'm saying that, because I just remember we're working on a term sheet that I'm working on now, and I was actually thinking about that. I looked, and there is no upfront fee. So it's not necessarily a box that even goes on this. I think I'm actually working on 2 startup licenses right now with no upfront fee. So I think in a lot of cases, the equity is the upfront fee. And it will depend on the university practices. So one other thing I want to mention about this, just generally on these economic terms, is that practices on how startup friendly a tech transfer office is going to be are going to vary a lot from university to university. And it's good to talk to whoever the technology manager is that's managing the specific patents or their technology to get a general overlay from them on what their philosophy is on upfront fees, on taking equity, and that type of thing. And then that can give you some ideas going in. Because generally, one thing I'd say is that the universities, especially the higher volume a university does, that it tries to be consistent and tries to be fair across their licensees, although super hard to do because the technologies are all different. All the circumstances are different on whether someone's negotiating with a venture capitalist ready to put a few $1 million in, or someone that's more going to bootstrap and get some SBIR money. So like everything varies, there's a lot of variation, but generally the tech transfer folks are there to help get it out, to help you get the technology out, and can share, their perspective on what they've seen and what the university is looking for. Because there are, frankly, there are some universities that are going to say, we don't want to license it until it's this far along and you've got $1 million of financing, so we expect more money. And just the practices are going to vary from university to university, but 0 is the lowest I've seen. And I don't think that's super uncommon. All right, so there's milestones, and milestones, there's milestones come up in 2 different ways when we look at the overall business terms of a license. And I guess I'm doing everything in reverse order. Maybe I might need to reorganize this, but the first one is diligence obligations. And so, we've talked about this. The university's taking it's a shared risk arrangement. The university's saying this intellectual property may be very valuable. On the other hand, you're a startup, we understand you don't have money, so we're going to get it out to you with not much upfront, maybe only equity and without cash. But the important thing for us as a university is that we want the technology to be fully developed for the commercial markets, for societal benefit. And since we've given you an exclusive license, that's a real problem for us if you don't go develop it. So from the university standpoint, there will invariably be what we call a diligence section that, and it might be worded different, but the essence of it is the same, is that the company is going to use diligent efforts to make the licensed products commercially available in whatever that field of use is licensed. And then I'll be including making these milestones by these deadlines. And these get negotiated. And so part of the licensing process at most universities is going to be, they're going to ask you for a technology development plan. And in that technology development, they're going to plan, okay, tell us what you're going to do to get the product out there, and tell us like what your rough timeline is for doing it. And those things that you put into your technology development plan are going to come back here. Okay, and the university will say, okay, well, you told us you're going to file an IND with the FDA within 2 years from the effective date, and so of the license. So, we'll give you some little more time, but maybe it's going to say file IND in 3 years. And the idea of these, and there can be language in there, and there generally is, negotiate some language for being able to extend that if everyone, using good faith efforts to move the technology forward. But these are, in some senses, mile markers by the university to make sure the technology is being developed. And they are just generally going to expect them. From the startup standpoint, it's important to only include milestones here that you have to make to bring your product to market. So if you want to have like a nice to have thing, well, we might go in this direction, it's a problem if you actually put it in here, because when you put it in here but then you pivot, then your milestones are off, and then you're either going to lose the license, or or more likely you're going to go back and renegotiate. So that is an important consideration when you're putting these milestones together. So the then an associated part of negotiating these milestones. Oh, and sorry, the last point I want to make about the milestones is the milestones are generally just going to take you to first commercial sale. So what the university is doing is, we want to see that you're making the progress to get you to having a product to market. And so milestones aren't going to go past you having commercially developed to get it to market. And the other thing about it is universities don't like seeing things that are like 5 years apart. And you say, okay, well, we're going to do this proof of concept, then we're going to have a pilot plant built 5 years from now, because the university is like, well, we like checking in more frequently then, because if you've fallen off the face of the earth in that period, we potentially don't know. So we want more frequent check-ins to make sure that you're developing it. So it's sort of a way of kind of coming up, where can we come up with some gradations of things we have to do to get the university comfortable moving along. And then another side of it, and these milestones don't necessarily match up one for one, but the university, as part of this sort of shared risk, is that there will be milestone payments. And these also can vary greatly, but this also, in my mind, this is also a good negotiating tool for the startup, because let me give an example. If you're developing a new therapeutic, once you get FDA approval, it's all, your whole company and everything is worth a lot of money. You're going to have access to a ton of capital. So, putting in here FDA approval, $2 million, like that's cheap for you to do, because there's very high risk. You can look at the expected value of getting there, but if you get there, you're going to have the wherewithal to make that payment. So it's also something to think about from the startup standpoint of maybe, depending on, therapeutic is an extreme example because the dollars can be so large, but depending what your technology is, that you can kind of come up with the appropriate numbers. Often these milestone payments are not 7 figures. Often they're 5 or 6 figures. But if you are looking at a big enough market like therapeutics, they can be. The other thing is the milestone payments are often based on product development milestones of getting the technology closer to market. But they can also be on like sales, and you can have milestone payments of, well, when we have our first $10 million, could be the first time we hit 10 million annually in licensed product sales, then you get a special payment. That can be helpful if you're trying to keep the royalty rate down, but the university is not happy yet, and you need to put some more economics in somewhere. So I'm going to go on then to the last part. Oh, you know what? We actually, and it was just a matter of just the one we did here. There's one economic term that's not highlighted here I'm going to cover, but here we have patent prosecution expense reimbursement. And from the university standpoint, once you basically, in the United States, the standard practices of most all universities and nonprofit research institutions is they're going to recover all of their patent costs from the licensee. So I've seen some cases where I'm hearing a little more flexibility on that, but the universities generally take a very firm stance on this. And this falls into 2 categories. One is the ongoing patent prosecution costs after the license is signed, and those typically will need to get paid as they're incurred or within 30 days. Basically within 30 days of billing. If in some cases, if there's large expenses coming up, the university may ask for payment up front. But that's going to be ongoing costs. From the startup's perspective, it's important to kind of understand what those costs are. And they can go to the Patent Prosecution Council and ask them and say, how do we expect costs to unfold? And that's going to depend a lot on whether it's just United States only, whether there's one patent or multiple patents. But if you have multiple patents that are going in multiple countries around the world, the costs really can add up. So that's the future patent costs. And then typically when you're doing the license, there's accumulated past patent costs. And those can maybe in the low $10,000 or in that neighborhood if it's just one application, or it could be much more than that if it's a big family of patents that's been around for a while. And often the starting point for the university may be that they're due up front. But again, for startups, there may be more flexibility in scheduling it out over months or a few years. And also it depends on the amount of money, because if it's 6 figures, if we're talking $100,000 and more, most companies are going to say, okay, let's have a schedule and we'll pay you maybe, a third, something at closing, as something at first anniversary, something at second anniversary, or maybe a little beyond that. And so that really encompasses, when you're talking about what do you have to pay when you sign the license agreement, all that's going to be required up front, is going to be, some or all of the past patent costs, the upfront fee, if anything, and then you're issuing the equity. But again, the equity is, not cash out of your pocket for the startup. Any questions, Matthew?
It looks like we have no questions in the Q&A, but it looks like we're approaching the top of the hour. So I want to reiterate that we have the Q&A function open, and if anybody has any questions on any of the topics that have been covered so far, definitely submit them in the Q&A function so that others attending can benefit.
Okay, and I think we've hit there's one other point I didn't, I think we've given people a good picture. There often will be a liquidity fee, and universities now more and more are negotiating that they get some minimum payout when the company is sold. And so we are seeing that, and often that'll be offset by any equity gains. But universities are to some extent protecting themselves that if their equity gets really diluted, that they'll still get some benefit on the sale of company. So I'm not gonna, I think we've covered a lot in that. So if there's no other questions on the term sheet, I actually will now go back to the slides. And I don't know how long, I think we've got an hour and a half scheduled. So I'm happy to keep going as long as folks are interested in going through this. Did another question just pop up, Matthew?
In your experience, what's the typical amount of equity that a startup should pay for a license?
Yeah, this is one of these areas where there's variation. And I'd say about 5 or 10 years ago, people would have said the median is about 5% at that time of founding, and that may be after raising a little bit of money, 5% of equity. And it does also depend on the technology, because for 5%, that should be a pretty foundational piece of technology for the company. What I'd say on the East Coast, we tend to see higher rates with just universities having some experience asking for and getting higher rates. Sometimes we'll see where the university's made a significant contribution of its investment of its own funds in a particular project and expect a higher rate. But I've also been seeing downward pressure on that 5% in the last few years. And so I'm, just as often maybe seeing things that may be coming in at 3 or 4%. But I'd say, if you asked me this question 6, 7 years ago, I would say it's usually coming in 4 to 6%. Now I feel like it's coming in a bit lower than that, but that's order of magnitude. And I see that there's another question, which is, are there free references or sources to find typical deal terms or ranges? There are, there's, in terms of centralized databases, the Association of University Technology Managers, which we're going to cite to in a minute, they actually have a database that where they collect the information. I don't know that that it's largely subscribed to. I haven't talked to many folks who are using that. There's several commercial databases where you can get royalty rates, but so there are several, and I don't have the names offhand. There are several ones, several commercial ones where you can go say, hey, I've got a medical device. What's the typical rate? And there's some that will actually do custom research for you, because they do tend to be specific. So let me give you an example, which is therapeutics right now. The royalty rate that we're tending to see on therapeutics is between 3 and 4% for preclinical therapeutics. That's where it is. It's not always the case. There can be circumstances it's a little lower, a little higher, but they tend to fall in that range. In terms of, like, if you're talking, if you're looking for the economic terms, that's where it is either the Autumn database or going to those commercial royalty rates are going to be the same one, or it's just anecdotally talking to people who do these. People like lawyers like us, or business development people who kind of work in these areas. But there's not like what there isn't right now, there's not a great centralized database of it. One thing I want to point out though is that a lot of university licenses actually get filed with the SEC though, that because companies will go public and there will be a university license as part of a material agreement related to that company. So you will see, if you go look at the publicly filed license agreements, you can see terms there. The economic terms tend to be redacted though, and they will stay confidential for a period of 10 years. So, when something's more than 10 years old, you can go back and there's sources who go and pull those from the SEC, or you can request them from the SEC after 10 years, but they tend to be a little stale after that period of time. I'm going to stop sharing my screen now and start sharing again with the slides. All right. So you're going to get these slides afterwards. I'm going to probably take a pretty high level pass through these slides right now, but Matthew will circulate these afterwards. And there's two subjects, the rest of these. One is intellectual property, and then the other is a little more looking at some other aspects of university licensing and IP. And you definitely don't need to be an IP expert to be licensing it, but if you're founding a company, it is important to understand what a patent is getting you and what it isn't getting you. And that's just, having done this for 16 years, I've seen very different expectations of people thinking that the patent that they're getting is entitled to something that it really isn't, that it thinks that this means that they're going to be able to do this, that no one else will be able to sue them, that they're going to have these moats built around their business because the patent. That may be the case or may not be. It's going to vary a lot by the patents, the nature of the IP that's being licensed. So it's helpful to get at least some rudimentary understanding, and often the best way to do it is to find a patent lawyer who is in your subject matter expertise, who you can talk about it, who can advise you generally what the landscape may look like, and also about the specific patent you're getting, or what patents you may want to pursue independently of the university patent. So the term intellectual property itself is actually, from a legal standpoint, it's not an actually very helpful term, because it refers to a broad category of different, and I can actually take issue with this Wikipedia definition. It really is referring to 4 very separate areas of the law, and that if you think of them together, you'll just get confused because they're different. The term intellectual property itself is very imprecise, and if you combine them together in your head, they just work very differently. And just this is an example where a client recently asked me, oh, there's these patents out there and someone's infringing them, so do the patent rights go away if you don't enforce them against infringers? And I think, well, that's a normal question to ask if it's someone who's familiar with trademarks, for example, because if you have a trademark and you allow other people to use it like generically, then you are going to lose, and it's going to dilute the value, and you might actually not be able to even enforce the trademark, because that's the nature of trademarks. It's this distinctive thing associated with a specific product. That's not the case with patents. You don't have to enforce patents, and they don't lose any value by not enforcing them. If you don't enforce things, then you can only enforce things that go 6 years back. So if you wait 7 years, you can sue somebody, but you can't get damages from 7 years ago. So there's that consideration. But just an example of these areas of law just operate very differently. So if you're actually the person licensing it, it's important to understand, like, what actually are you getting? Because patents can be very different than getting something that falls more in the trade secret or copyright area. So patents often will have the most value if it's a strong patent. And the reason is, and this slide references, there's 3 different kinds of patents. Usually when people are talking about patents, they're talking about utility patents, and that's going to be the sole focus of what I'm going to talk about for the next few minutes here. And the utility patent provides the right, and these are such key words, to exclude others from making, using, offering for sale, selling, or importing an invention. And the right to exclude is so key because it actually doesn't give you the right to do anything other than to stop other people. So if you get a patent license from the university, that doesn't mean that when you use that patent to make products, that someone else might sue you. And that's sort of a little more in-depth conversation than we have time to do for today. But the patents don't give you an affirmative right to do something. They simply give you the right to exclude other people. So your patent, the patent that the university has may be an improvement on something else that also is patented, and you can't use that improvement without getting rights to the initial invention. So again, that's going into explaining all that's beyond the scope of what we're going to cover today, but it just gets to the point of really understand what you're getting. And that even if you're getting this patent, you may need to do some work to figure out, hey, are there other people that have patents that I need to make this product? There are elements you must meet to actually get the patent issued. And that's in the fourth bullet point here. It's a utility patent is for a novel, non-obvious, and useful process, machine, article matter, composition matter, improvement of any of the foregoing. So these are actually things that need to be satisfied. If you heard the term prior art before, that gets to this question of novelty, because if someone has actually come up with the same invention or discovery and published on that before you file your patent application is going to lack novelty because you were not the first person to file an application, or at the time you filed the application, even if that person didn't file an application, at the time you filed the application, the discovery that was in there was not novel because someone else had already published the discovery. And that the idea of co-discovery happens a fair amount of time. And a patent is something you actually have to do something affirmatively to get the rights. You actually have to go out and you have to file something with the government authority, and the government authority is going to examine it and decide whether you're entitled to it before it grants you the patent application. Because the patent actually ultimately can become this very powerful thing because it gives you this right to exclude others, which means someone else could completely innocently, independently develop a product and start selling it, have no idea about your invention. But if it practices what you've patented, you can stop them. You can sue them or get damages. And Matthew, are there any questions? No, I see you unmuted.
So far, no. So far, no questions.
All right.
I did want to comment that we've hit the top of the hour. I usually allot the hour and a half just in case we go over with questions. If you wanted to move towards wrapping up, that'd be
okay. Great.
As well.
Yeah, that's fine. I don't really have the slides when we published. This is more like there's a lot of background stuff here. Yeah, and I didn't know we covered really the meat of what I wanted to cover. There's background things that are included in the slide that explain. The previous stuff is more just the IP, which is really IP basics, which people may have already been exposed to. Here we get more into the background of it, the federal law that kind of created the modern tech transfer system that allows universities to own the patents and also really influences the licensing model that's used in the United States. It's important also that when you're licensing to understand that there's underlying university IP policies that will bear on what the university owns and doesn't own. And also it's good for people to understand that when the university makes money from it, they're actually sharing a portion of this money with their inventors, and that's all governed by the university IP policy. And in the slides, we have links to the UCLA policies that are most of them are UC Regents governed. There's some statistics in here on the amount of the volume of activity, kind of just talks through the licensing process. Key terms, we hit a lot of these key terms. Some things to think about in terms of doing your own diligence, both from an IP standpoint and a technology standpoint. I'll touch on that, which is we talked about potentially getting an option. And it might be that the people licensing the technology out or coming out of the lab and they're very comfortable with it and know the limits and what the technology can do. Could be it's someone from the outside who doesn't and would actually like to evaluate the technology before doing the license. And so sometimes there'll be an evaluation agreement at the front end where the potential licensee can do some experiments. So those are just some general considerations, some just general considerations generally on thinking about overall IP strategy. And yeah, we don't need to cover this now if we're kind of hit our time limit. So that's it. With that, I'll wrap up. Yeah, I mentioned who we are previously. What we do is we focus on working with early stage companies that helping them with their corporate and their licensing needs. And we do work with a lot of folks who are taking intellectual patents and other technology out of universities. So that'll wrap up my side. I'm happy to take whatever other questions there are.
All right, we've got one from Albert McHale. I'm not sure about the phrasing of that question. What's the feeling on filing provisional versus unpublished versus standard utility patent when you're midway in the development phase but hope to be on the market within a year?
Can you repeat that one more time? Because there was a lot of content. I want to make sure I got that parsed out.
Yeah. Your opinion on filing provisional versus unpublished versus standard utility patents when you are midway in the development phase but hope to be on the market within a year?
So, in that case, I'm a fan of filing provisionals. I mean, and I just coming from the university background, that is the standard starting place. If you're in a hurry to get the patent issued, and because of the way the market's evolving, you want to get issued claims sooner rather than later, then you might want to skip the provisional. But especially from a startup standpoint, filing a provisional can be a good way to kick the can a little ways down in terms of costs that will add up. So there's another practice also is you file a provisional and you may not have all the data you want yet, and you may want to do more experiments in something, and so that when you gives yourself that year to file it. So typically the provisional is going to get filed in the United States and for a US company, and then you're going to have to make a decision when you come to your conversion on whether you're going to actually want to file a PCT at that point. That's a critical strategic decision. Often companies, if they still have the ability to pursue foreign rights, will file a PCT to keep that optionality open. And then you got 12 months to go from the provisional to non-provisional. And when you file a PCT, you're giving yourselves a total of 30 months from your initial filing, 2.5 years, to decide whether to nationalize and incur all that expenses of going to countries around the world. So I guess without knowing a little more, I'd say provisional is a good place to start. But filing, and we're not patent prosecution experts, but we'd say the more fulsome of a provisional you can file with the more detail you can get in the provisional, as well as including claims, at least some claims in the provisional, is a good thing. From just what, our experience in working around the area and advice from Patent Prosecution Council.
Right. Well, with that, we've reached the top of the hour, so I think here's a good place to wrap up. So, Rick, I want to thank you for joining us this year for the Business of Bioscience Bootcamp. And I want to thank all of our guests for joining us these past 5 weeks for getting to a better understanding of the tasks and tactics for getting medical devices and bioscience on the commercial market. So thank you, and look forward to seeing all these videos and slides available on the New Ventures website. Rick, thanks again.
Okay, thank you, Matthew.